Welcome back, everybody, to our studies in land law. This lesson is going to talk about the next process by which the acquisition of an easement may take place, this time through the process known as prescription of easements. Now, I would like to warn you to begin with that this is a particularly convoluted, complicated, and in my opinion, quite stupid area of law that has some quite unfortunately worded legislation that makes it complex. So feel free to not feel too bad about not understanding it, not getting it straight away. We will go through it in as slow detail as much detail as possible, at a slow pace. But for it, like I said, if there was some lessons that I did on trusts that had sort of similar elements of complexity to it, like the Van der Waal exception, for example, and I encouraged the students who were studying trusts to basically go, right, watch this a couple of times and don't feel bad if you don't understand it. Not all of law is easy, unfortunately. But this lesson is going to talk about prescription of easements, as I've mentioned. This is the final lesson that we're going to be doing on the ways in which easements are acquired, the acquisition of easements, and we will examine the niche circumstances in which an easement can be implied through the issuance of prescription. Now, implication through prescription is where an easement has existed for a long period of time and existed over a piece of land for a long period of time, but that there is no deeds or that there aren't any traces of the prescription. If that is the case, if it is sort of just like, well, we have this easement here and it seemingly has existed for ages, and nobody knows where it was originally cited, where it was originally written down, or where any trace of it, then if that is the case, then it may be implied that that easement exists. There are three main ways in which we can actually see the prescription of an easement. The first way is prescription through the common law. Secondly, we can talk about the fact that there may be the loss of a modern grant. And then finally, the unfortunate 1832 Prescription Act, which we're going to have to spend a little bit of time looking at. Just bear in mind, the Prescription Act, the wording of some of the legislation in the Prescription Act is so convoluted that even the courts have said it's poorly written. So there you go. That's and you know how terrible sometimes judges write. So imagine imagine how bad it must be if they think that it's poorly written. Okay, so bear that in mind. So these are the three ways in which we can see prescription occur. Beginning first then with the common law prescription of an easement. In order to show an easement by prescription under this first route, through the common law, it must be shown that it had the ability to be exercised since, quote, time immemorial. What does this mean? Well, essentially, time immemorial actually refers to a specific date. It refers to a specific time period. And the idea of time immemorial is supposed to be the ways in which we essentially date the point at which the common law begins. Now, the common law obviously developed quite slowly, but we would suggest that the ascension of Richard I to the throne in 1189 and the sort of Angevin Empire that was created is really in and around where the common law is created. Obviously, it has traditions all the way back into Anglo-Saxon legal systems. It has dates itself. It has little traces and touches from the Roman law, but we suggest here that from time immemorial is the time at which the common law begins, which is 1189. Okay, so in order to satisfy that an easement can be implied through prescription, it must be shown that it had the ability to be exercised since 1189. There can be a rebutting of the presumption where evidence is adduced to show that it cannot have been enjoyed since time immemorial. So obviously, the point here isn't to try and trace and go through the historical archives and find evidence that this easement was used in 1189, or it was enjoyed in 1189, or evidence that it even existed in 1189. The point here is to suggest that it could have been used in 1189. So, for example, an easement for light which came through a window that was built in the 1920s cannot be said to have been able to be exercised from time immemorial. If instead you had a farmstead, for example, that had sort of a field on one side, and maybe you had a right of access, and you want to show that you have a right of access into that field, if you can show that this had existed from time immemorial, had the capability to exist from time immemorial, which of course you would probably be able to if those farms had sort of existed from that long, then you can maybe come to the assumption that this actually could be an easement which is prescribed in the common law. But yeah, things like an easement for light which comes through a window that was built in the 1920s does not count, because obviously that was an easement which would not be capable of being utilized prior to the 1920s, because that window didn't exist, because the building didn't exist. So that's how we sort of think about that. If you can show that it has been that the right has been enjoyed for 20 years, however, the rest of the time will be presumed unless that presumption can be rebutted. This is a very important point. So if you go into a court of law or go into a solicitor's office and they say, well, if you want to show a prescription through the common law, we have to show that this easement was able to be exercised since 1189. You might look a bit sheepish, and you might look a little bit blue at the idea of trying to do that. And so really, there is a presumption that is attached. So if you can show that the right has been enjoyed for 20 years, then it will be presumed that this easement could be enjoyed since time immemorial, unless that can be rebutted. So theoretically, okay, a window that was built in the 1920s, you could show that has been enjoyed for 20 years, and so there will be a presumption that it could exist from time immemorial. But then, of course, that presumption can be very easily rebutted by the fact that it was built in the 1920s, okay? But prior to that rebuttal, there is a presumption that it existed from time immemorial. It is only with the rebutting of that presumption, which obviously can very easily be done if you show that the house was built in the 1920s, that's when that happens. So really, the ways in which the ways in which prescription under the common law operates is actually quite nice for the person who wants to acquire the easement, because there is just a basic presumption of an exercise from time immemorial, so long as you can show that it has been enjoyed for at least 20 years. And then obviously it is up to other people to try and rebut that presumption by showing that either the building didn't exist, or that it was impossible that it could have been enjoyed from all that long ago. That's essentially how we do the common law granting of an easement. The second way in which we can do this is through the loss of a modern grant. If one can show the existence of the use of an easement for more than 20 years, then the courts could presume that there has been a grant of an easement that has been enjoyed in the past, but that has just been lost to time, okay? Again, this is another thing that is showing that they're quite nice for the people who are trying to acquire at least a formal acquisition of an easement. So if you can show, look, there's an easement here, and it's been used for more than 20 years, we don't have any documentation of where it was granted, we haven't got any documentation of some court order which implies it's granting or anything like that, but we can show here that it's been used for 20 years. The courts will respond and go, well, okay, if you can show that it has been used for more than 20 years, but you can't show me that there is any title deeds or any grant of that easement itself, then we will just presume that there has been a grant of that easement in the past, and that just has been lost, okay? Now, the interesting thing here is no one can rebut this presumption by saying that no grant was ever made, essentially trying to prove a negative to suggest that there was no grant ever made. In order to rebut this presumption, you would have to show that a grant would have been impossible to have been made, okay? That is how you rebut the presumption, or alternatively, theoretically show a grant which expressly denies the granting of this easement. But again, if you can't find a grant in the first place, then that won't be very possible either. Fundamentally, you have to show not that, look, there hasn't been a grant So therefore, we shouldn't give this. You shouldn't be able to presume and prescribe this easement, because then that is saying you're trying to prove a negative there. That would be impossible, and that would be a particularly low evidential standard. Instead, what you're going to have to do is say, right, no, the courts. I know you are presuming that there has to have been a grant in the past, but here's some evidence to show that this grant would have been impossible to be granted in the past, and so therefore we're going to rebut this presumption. Okay. Thirdly, then, and finally, the Prescription Act from 1832, the one I've been avoiding all this time. Okay, the Prescription Act, as I've read in here, and as I've said at multiple points, is difficult and complex, also poorly drafted, and is a pile of a word I'm not going to say. Don't take my word for it, take the conclusions of the House of Lords in the case of Flight and Thomas. However, under this legislation, a number of things are indeed established. Firstly, if one can establish 20 or 40 years of uninterrupted use of an easement, it may be acquired by prescription. This is the case for all easements other than, with the exception of, easements of light. The two time periods, short and long, are able to be rebutted by either oral/written consent in the case of the short period, or just written consent in the case of the long period. The qualification of an interruption must be at least that of a year. And then if the easement is a right to light, which was obviously provided as an exception, it has to have been uninterrupted for 20 years. This will be taken as an absolute and indefensible easement. That is essentially the Prescription Act, okay? I'm not going to go into too much detail. If you want another lesson on the Prescription Act, in all seriousness, let me know in the comments down below, and I'll put another video unpacking the Prescription Act in a bit more detail if you really want. Again, the Prescriptions Act is convoluted, stupid, difficult to understand. Don't feel bad if you don't get it. I hate it too. So don't worry about it if you don't understand it necessarily. Notice here I've spent very little time talking about the Prescription Act. Often, in fact, the Prescription Act isn't really cited as many times anymore. It's quite an old, outdated piece of legislation. Obviously, that doesn't stop an examiner or a professor in land law giving you a problem question that requires you to engage with the Prescription Act. But at least in terms of the real world, it's probably not that likely that you're going to run into having to unpack and dig into the weeds of the Prescription Act. Especially given there's all these other express grants of easements, and there's all these other implied grants of easements, and there's obviously the other types of prescription as well. But just bear that in mind when you are thinking about problem questions. Don't overlook it if you think it's particularly convoluted. Make sure you still obviously spend time revising and studying this topic as well.